This is the Study for the Bar in Your Car podcast.
We're your hosts, Maude and Claude.
And you're listening to episode 24, all about constitutional law. Specifically, we're diving into the Ninth Amendment today.
That's right. And if you're like, well, countless dedicated law school graduates out there really grinding away, preparing for the bar exam, you definitely know every single minute counts.
Absolutely.
So our goal today is to, cut through some of the noise. We want to give you a focused, pretty in-depth understanding of one of the Constitution's, well, let's face it, more enigmatic provisions.
And we're doing that using the really comprehensive constitutional law outlines put together by Angela.
Exactly.
We are, as you know, AI bots.
Yeah. We're
brought to life by the magic of AI and Angela's really invaluable constitutional law notes.
And for those who might not be familiar with the mind behind these excellent resources, Angela graduated with an LLB from the University of Law in London.
Right, and then she didn't stop there. She went on to George Mason University to pursue not one, but two additional law degrees.
Her dedication is pretty remarkable. And beyond putting together these notes that help us make these podcasts, Angela also works as a freelance remote law clerk.
That's a key point. So for any attorneys listening, or maybe you know an attorney who could use some help.
Yeah, assistance with, say, deep LexisNexis or Westlaw research, or maybe drafting motions, complaints, answers, appeals, that kind of thing.
Angela's expertise is available. Just shoot her an email at hello@legalwriterandlawclerk.com.
And if you need to contact Angela about the podcast itself, maybe feedback or questions.
All right. That email is podcast@studyforthebarinyourcar.com.
Perfect. So let's talk about our mission for today.
Okay. Our mission really is to equip you, yes, you, our focused law school graduates getting ready for that bar exam with a, let's say, nuanced understanding of the Ninth Amendment.
Now, you might be thinking, hang on, the Ninth? Is that really like a high-yield topic for the bar?
It's a fair question. It often gets overshadowed, doesn't it, by its more famous siblings in the Bill of Rights, almost like a constitutional sleeper agent.
That's a good way to put it. But here's why it's actually profoundly important, even if it doesn't show up constantly as the main issue.
Okay, lay it on us.
Well, it might not always be the primary explicit reason for a constitutional challenge, not like the First or 14th Amendments often are its underlying principles. They're absolutely foundational.
Foundational how?
Well, they quietly underpin entire areas of constitutional law, especially when we start talking about rights that aren't, explicitly written down in the text.
The unenumerated rights. That's where the Ninth really comes in.
Exactly. The Ninth Amendment isn't just some textual curiosity. It's a really profound philosophical statement, and crucially for lawyers, a vital rule of interpretation.
It's like the Constitution's way of saying, hey, this isn't everything.
Precisely. It's the safeguard against a pretty scary idea, the notion that the government gives us our rights.
Right, it flips that. It says the rights are already there.
It reminds us that our rights pre-exist the Constitution. The document just affirms some of them. That's a critical distinction, often glossed over. But it fundamentally shapes how we view individual liberty in the U.S.
Understanding that difference, that subtle but powerful concept, can really elevate your whole approach to constitutional questions on the bar exam.
Absolutely. It's about the source of rights. Do they come from government or are they inherent? The Ninth points strongly to inherent.
Okay, so let's get into the specifics. Let's start by pulling back the curtain on this amendment and reading its precise wording. This is straight from Angela's comprehensive outlines.
Okay. The Ninth Amendment states, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people."
Short, but packed with meaning. Shall not be construed to deny or disparage others retained by the people.
It's succinct, yeah, but it holds a really pivotal position in our constitutional framework, even if it's sometimes dismissed or, frankly, misunderstood.
So the core concept right out of the gate is this idea of unenumerated rights.
Exactly. These are the rights retained by the people, fundamental liberties that, well, they exist inherently. Whether or not they happen to be explicitly listed or enumerated in the Constitution or the Bill of Rights doesn't diminish their existence.
Which makes the Ninth Amendment more than just a statement, right? You called it a rule of construction.
Yes, it's a powerful one. It's basically a directive for interpreting the whole document. It tells us as legal thinkers, future lawyers, judges, how to read the Bill of Rights.
And not to read it.
That too. It explicitly warns against falling into a dangerous trap. interpreting the absence of a specific right in the text as proof that the right doesn't exist.
Or worse, that it's been given up, surrendered to the government.
Precisely. That's the deny or disparage part. Listing some rights shouldn't be used to undermine or weaken the ones that aren't listed.
So the framers were basically installing a kind of textual firewall. They were saying, look, we've listed some crucial rights here, but don't you dare assume this list is exhaustive.
And definitely don't assume that any right not on this list suddenly vanishes or falls under government control.
It's a fascinating safeguard.
Yeah.
And that takes us right into the historical context, doesn't it? Why did they feel the need to put this in?
Oh, absolutely. It wasn't created in a vacuum. It was a direct and pretty ingenious response to some very real anxieties during the really heated debates over ratifying the Constitution.
The Federalists versus the Anti-Federalists.
Exactly. The Anti-Federalists in particular had this deep and I think legitimate fear about adding a Bill of Rights at all.
Which sounds weird now, right? We think of the Bill of Rights as essential.
We do now. But their concern was this. If you explicitly list certain freedoms, say freedom of speech, freedom of the press, you might inadvertently create a dangerous implication.
The implication being?
That any rights not specifically mentioned were therefore implicitly surrendered to the new, more powerful federal government. They worried that the very act of listing rights would disparage those rights not mentioned.
So simply by omission, you could limit the inherent natural rights citizens already possess.
That was the fear. And James Madison himself, who we think of as the architect of the Bill of Rights, acknowledged this was one of the strongest arguments against having a Bill of Rights.
Right. Angela's law school notes really highlight Madison's thinking here. He saw this wasn't just a minor technical point.
No, it was a fundamental philosophical objection that seriously threatened the Constitution's ratification.
And Angela's notes quote him explaining his precursor to the Ninth Amendment. He basically said it was designed to guard against these most plausible arguments.
Yeah, he laid it out pretty clearly. He said, and I'm paraphrasing slightly from his commentary, that people objected that listing specific exceptions to government power might disparage the rights not listed.
And it might imply that those unlisted rights were now in the hands of the federal government and insecure.
Right. And Madison said, this is one of the most plausible arguments I have ever heard urged against the admission of a Bill of Rights into this system, but I conceive that may be guarded against.
Guarded against. That's the key phrase. The Ninth Amendment is that guard.
It absolutely is. It's a testament to their foresight, really. They understood the limits of language and just how vast individual liberty is. You can't list everything.
So the Ninth was Madison's clever way to kind of inoculate the Bill of Rights against that specific criticism, making sure it acted as a protective floor, not a restrictive ceiling for our liberties.
Exactly. And this whole debate also puts Madison's view in contrast with someone like Alexander Hamilton.
Hamilton had a different take entirely, didn't he? In Federalist number 84.
Oh, yeah. Hamilton was deeply skeptical about needing a Bill of Rights at all. His famous line was basically, "Why declare that things shall not be done which there is no power to do?"
Meaning, the Constitution already limited the federal government to specific enumerated powers. So if the power wasn't granted, the government couldn't exercise it anyway, right?
That was his logic. For Hamilton, adding a list of don'ts was not only unnecessary, but potentially dangerous. It might imply the government could do anything not on that forbidden list.
So two very different philosophies on how best to protect liberty.
And the Ninth Amendment was Madison's, you could say, elegant compromise. It addressed the Anti-Federalists' fears without fully adopting Hamilton's skepticism about the whole Bill of Rights project.
So it was meant to be this crucial protective constitutional asterisk, basically saying contents not exhaustive, other rights still apply.
That's a good way to think about it.
Yet, despite that clear, important intent for a huge chunk of American legal history, the Ninth Amendment just sort of sat there.
It really did. Angela's outlines point out it was often considered forgotten or even irrelevant in federal courts for almost 2 centuries.
While other clauses, like, the Commerce Clause or due process, were constantly being fought over, why did the Nines lie dormant for so long?
That's a great question, and it gets to a really fundamental tension in how we interpret the Constitution. For a long, long time, courts were just deeply hesitant to use the Ninth Amendment as a direct, substantive source for establishing new rights.
Why the hesitation? The language seems clear enough. Others retained by the people.
It seems clear, but the ambiguity of which others made judges very uncomfortable. Was it just a philosophical nod? Was it only meant to help interpret other amendments? Or was it, a blank check for judges to discover new unwritten rights.
The judicial activism concern.
Exactly. Many feared that reading it as a direct source of rights would give unelected judges way too much power. It could allow them to effectively legislate from the bench, imposing their own personal views about what counts as a fundamental right.
So that fear of judicial overreach basically kept the Ninth Amendment on the shelf for generations. A silent guardian, as you said earlier, just waiting.
Pretty much. It was there, but judges weren't quite sure how to wield it without, breaking the separation of powers.
It's really interesting how different legal scholars have tried to grapple with its actual purpose. Like Professor Lawrence Tribe, a giant in constitutional law.
Right. Tribe's view, generally, is that the Ninth Amendment is primarily a rule of construction. He basically says, it is not a source of rights as such, it is simply a rule about how to read the Constitution.
So for Tribe, it's more procedural. It guides how we understand the scope of the rights that are listed or maybe protected elsewhere, rather than granting specific new rights all on its own.
That emphasizes its interpretive role, yeah. But then you have other scholars who see it much more broadly.
Like Bernard Bailyn, the historian.
Exactly. Bailyn suggested it points to a universe of rights possessed by the people, latent rights, still to be evoked and enacted into law, like a reservoir.
A reservoir of other unenumerated rights that the people retain, which in time may be enacted into law. Well, that's a much more dynamic view. It sounds like a potential source for evolving rights.
It definitely is. And then you have someone like Brian Dougherty who connects it directly to the natural rights tradition.
The idea that we're born with rights.
Yes, that we are born with more rights than any constitution could ever list or specify. This view ties the Ninth Amendment right back to the philosophical bedrock of American liberty, the idea that fundamental rights exist before government and independently of any written text.
So we have the spectrum, from a rule about reading the Constitution to a reservoir of potential rights to an affirmation of pre-existing natural rights.
Right. And even if courts hesitated to use the Ninth Amendment as the sole textual hook for a long time, that powerful underlying idea, that reservoir concept, still deeply informs how fundamental liberties get protected.
Which brings us to that phrase Angela's outlines highlight. The protection of unenumerated rights considered deeply rooted in this nation's history and tradition.
Yes. That deeply rooted standard is absolutely critical. It's a phrase you see constantly in substantive due process analysis. It's the court's attempt to find a principled way to identify and safeguard fundamental liberties that aren't explicitly listed.
How does that work, exactly? How do they determine what's deeply rooted?
Well, courts look to long-standing societal practices, deeply held beliefs across generations, the nation's historical experience. It's an effort to ground the recognition of these unwritten rights in something more objective than just the judge's personal feelings.
So it's a way to tether these unenumerated rights to some kind of historical legitimacy, trying to avoid that arbitrary judicial creation of rights we talked about.
Exactly. It provides a framework, even if the Ninth Amendment isn't always the explicit clause being cited. And its influence goes beyond federal courts, too.
How so?
Angela's notes mention how the Ninth Amendment encompasses rights derived from common law. Those rights built up over centuries through judicial decisions. And importantly, it inspired baby Ninth Amendments in many state constitutions.
Baby Ninths.
Yes, state-level provisions that often explicitly protect unenumerated rights, sometimes even more clearly than the federal Ninth. It shows the original idea had a wide impact, even if the federal courts were slow to embrace it fully.
Okay, so this historical dormancy, this period of the Ninth being forgotten, that finally changed, didn't it? There was a pivotal moment.
There absolutely was. The landmark 1965 Supreme Court case, Griswold v. Connecticut.
Griswold.
Yeah.
That's the case about contraception.
Yes. It's centered on a really old and frankly bizarre Connecticut statute that banned the use of any drug or device to prevent conception, even by married couples. And it also banned assisting someone in doing so.
So it was a direct state intrusion into, well, the bedroom. A challenge to marital privacy.
Precisely. And Griswold is where the Ninth Amendment finally stepped into the spotlight in a big way.
How did that happen?
It was largely thanks to Justice Arthur Goldberg's powerful concurring opinion. He argued forcefully that the Ninth Amendment provided a solid constitutional basis for discovering fundamental human rights beyond the Constitution's text.
So he saw it as the textual justification, the affirmation of these unlisted liberties like marital privacy.
Exactly. For Goldberg, the Ninth wasn't just a rule of construction. It was proof that such fundamental unenumerated rights existed and were constitutionally protected. It gave the court the explicit textual authority it needed, in his view.
But the main opinion, The majority opinion by Justice Douglas took a slightly different path, right? The famous penumbra theory.
That's right. Justice Douglas didn't rely solely or even primarily on the Ninth. He argued that various specific guarantees in the Bill of Rights, while not explicitly mentioning privacy, create zones of privacy.
Zones of privacy, like emanations.
Exactly. Emanations was his word. Think of it like light spilling out from the explicit rights. The First Amendment protects freedom of association, which implies a private associational space. The Fourth protects against unreasonable searches, creating privacy in one's home and person. The Fifth protects against self-incrimination.
And the third, the one about quartering soldiers.
Yes, even the Third Amendment. Douglas argued that these specific rights, taken together, have penumbras, formed by emanations from those guarantees that help give them life and substance. And within these combined shadows or zones lies a constitutionally protected right to privacy.
It's a really creative interpretive approach, using the listed rights to justify protecting an unlisted one.
It is, and the link to the Third Amendment is fascinating. It seems so archaic now, right? Prohibiting quartering soldiers in private homes without consent.
Seems like a non-issue today.
Mostly. But Angela's outlines point out how Griswold used it as a prime historical example of a guarantee creating zones of privacy. It symbolized, as the notes say, the traditional and strong resistance of Americans to any military intrusion into civilian affairs.
So even that seemingly narrow old amendment helped build the foundation for the modern right to privacy.
It did, and Angela's notes even mention a later case, Ingleham v. Carey. It's apparently one of the few federal appeals court cases to really dig into the Third Amendment.
What did it say?
This was 1982, Second Circuit. The court actually recognized the Third Amendment as being designed to assure a fundamental right of privacy. And crucially, it held that the Third Amendment is incorporated against the states through the 14th Amendment's Due Process Clause.
Wow. So even that amendment isn't totally obsolete and applies to state actions too, reinforcing this idea of privacy zones.
Exactly. Ingleham shows how even specific historical provisions can be read to protect broader fundamental rights like privacy, fitting right in with the spirit of the Ninth and the penumbra theory.
Now, naturally, not everyone on the court bought the Griswold reasoning, especially this discovery of an unwritten right to privacy, whether through the Ninth or penumbras.
Oh, definitely not. The dissenting justices, particularly Justice Black and Justice Stewart, were vehemently opposed.
What was their main argument?
They basically argued that the Ninth Amendment wasn't meant to be a source of new rights enforceable by courts. They saw its purpose primarily as preserving the balance of power, reinforcing that the federal government had limited powers, and everything else was left to the states or the people, as the 10th Amendment clarifies.
So back to that fear of judicial overreach. They thought the majority was just legislating from the bench.
That was the core of their dissent. They worried judges were imposing their own moral or social views by discovering rights like privacy that weren't explicitly in the text. They saw it as fundamentally undemocratic.
Which raises that huge ongoing question, especially for you studying for the bar. Where do judges draw the line? How do they protect unenumerated rights without just becoming a super legislature?
That is the perennial question, and it leads us straight into one of the most contested areas of constitutional law, substantive due process.
Substantive due process. Okay, break that down.
Right. So the due process clauses of the 5th and 14th Amendments say the government can't deprive anyone of life, liberty, or property without due process of law.
We usually think of due process as procedures, right? Like, notice a fair hearing.
That's procedural due process, and it's vital. But substantive due process is different. It says that the liberty protected by the Due Process Clause includes certain fundamental rights that the government cannot infringe upon, regardless of the procedures used. The substance of the law itself is unconstitutional if it violates these core liberties.
So it's not just how the government acts, but what it's doing. It limits the actual substance of laws.
Exactly. If a law infringes on one of these fundamental substantive rights, the government needs a very, very compelling reason for it. And the spirit of the Ninth Amendment, recognizing inherent unenumerated rights, works right alongside this concept.
Okay, that's a critical distinction for the bar. So can you give an example of substantive due process in action, protecting an unenumerated right?
Absolutely. A major, very current example is the Obergefell v. Hodges case from 2015, the one that recognized the fundamental right to same-sex marriage nationwide.
Obergefell, how did the court use substantive due process there?
Well, Obergefell is really a masterclass in how the court identifies and protects these unenumerated fundamental rights. The court explicitly recognized the right to marry as fundamental, protected by the liberty component of the Due Process Clause.
How did they decide it was fundamental? Did they use that deeply rooted standard?
They discussed that standard, yes, but they also talked about rights that rise from a better informed understanding of how constitutional imperatives define a liberty that remains urgent in our own era.
Ah, so it's not just history. It can also be about an evolving understanding of liberty.
Precisely. That better informed understanding language is key. It allows the Constitution's meaning of liberty to adapt over time while still demanding a connection to core constitutional principles. It's not just about what was always done, but about what our understanding of liberty requires now.
And Obergefell didn't just invent this right out of whole cloth, right? It built on previous cases.
Definitely. Angela's outlines remind us the court had already affirmed the right to marry as fundamental many times. You had Loving v. Virginia in '67, striking down interracial marriage bans.
Right, declaring marriage a vital personal right.
Then Zablocki v. Redhale in '78, which struck down a law-burdening marriage for people with child support debts. And Turner v. Softly in '87, confirming even prison inmates retain a fundamental right to marry.
So these cases built a foundation under the Due Process Clause. Obergefell extended that fundamental right to same-sex couples, reflecting that evolving understanding of liberty in marriage.
Exactly. It recognized that denying the right demeaned same-sex couples and violated that fundamental liberty.
And didn't Obergefell also mention the Equal Protection Clause?
It did. The court noted a synergy between due process and equal protection. While the main holding rested on the fundamental right under due process, denying that right also created inequality, violating the Equal Protection Clause. It shows how these clauses often work together.
Makes sense. But again, this idea of courts defining fundamental rights through substantive due process, it's controversial.
Extremely. Justice Clarence Thomas, for instance, wrote a powerful dissent in Obergefell, and he reiterated these points later in the Dobbs case, overturning Roe v. Wade.
What's his core critique?
He argues passionately against what he calls the dangerous fiction of treating the Due Process Clause as a font of substantive rights. He believes the clause only guarantees process fair procedures before the government takes away life, liberty, or property. It doesn't, in his originalist view, protect the substance of the liberty itself.
So he thinks this whole line of cases, from Griswold to Obergefell, fundamentally misreads the Constitution.
Yes, he argues it distorts the constitutional text and, critically, invites judges to roam at large in the constitutional field, guided only by their personal views.
Back to that judicial activism fear again, that judges are just imposing their own policy preferences instead of interpreting law.
That's the heart of the critique. It's a fundamental, ongoing debate about the proper role of the judiciary in protecting rights not explicitly listed. You absolutely need to understand both sides of this debate for the bar exam.
Okay, so this philosophical clash has real practical consequences, especially for how courts review government actions, right? The level of scrutiny.
Absolutely. It ties directly into judicial scrutiny. When the government passes a law or takes an action that regulates an area with a lot of constitutional value, meaning it potentially infringes on one of these fundamental rights, often protected via substantive due process and echoing the Ninth Spirit.
Like privacy, marriage, family decisions.
Right. In those cases, courts are much more likely to apply the highest level of review, strict scrutiny.
Strict scrutiny. Okay, what does that mean in practice for a bar exam question?
It means the government has an incredibly high bar to clear. To uphold the law under strict scrutiny, the government must prove two things. First, the law is necessary to achieve a compelling government interest. Not just legitimate, not just important, but compelling. Vital.
And second?
Second, the government must prove the law is the least restrictive means available to achieve that compelling interest. It has to be narrowly tailored, basically. If there's any less burdensome way to achieve the goal, the law fails.
So it's the toughest test, reserved for fundamental rights or suspect classifications like race?
Exactly. The constitutional value the court assigns to the right at stake directly dictates the level of scrutiny. High value, like a fundamental right. Strict scrutiny, lower value, a lower standard.
So if you spot a bar exam fact pattern where the government is interfering with something like privacy, marriage, raising kids, your brain should immediately flash strict scrutiny.
That's the trigger, yes. It signals the government has a massive burden of proof. It's the court saying, you need an exceptionally good reason for this, and you better have done it in the absolute narrowest way possible.
And what's the alternative if it's not a fundamental right?
Then the court usually applies a much lower standard, typically rational basis review. This is way easier for the government. The law just needs to be rationally related to any legitimate government interest. The burden is on the challenger to show there's no rational connection.
Big difference in who has the burden and how strong the government's reason needs to be.
Huge difference. Understanding which level of scrutiny applies is often the key to unlocking the right answer on a constitutional law question.
Okay, so wrapping this all together for someone studying for the bar. The Ninth Amendment itself might not be the clause you argue directly from most often.
Probably not. You're unlikely to get a question saying, argue this case only using the Ninth Amendment.
But its principles, this idea of unenumerated retained rights, are woven into the fabric of fundamental rights analysis, especially under substantive due process.
That's the crucial takeaway. Understanding the Ninth isn't just about memorizing its text, it's about grasping the philosophy behind it, the idea that our rights aren't limited to what's written down.
It provides the context for understanding Griswold, Obergefell, the whole debate around substantive due process, and why certain rights get that heightened protection under strict scrutiny.
Exactly. It helps you understand the bigger picture of how individual liberties are protected, even when they aren't explicitly listed. It reminds us that the Constitution affirms a broad realm of freedom retained by the people.
Mastering that subtle but profound concept will definitely strengthen your analytical toolkit for the bar exam and, frankly, for practice afterwards.
Couldn't agree more. It deepens your understanding of liberty itself.
And that brings us toward the end of our podcast, exploring the fascinating, sometimes overlooked, but truly important Ninth Amendment.
We really hope this discussion, looking at the history, the court battles, the scholarly debates, and how it connects to things like privacy and substantive due process, has helped clarify these complex ideas for you.
Understanding these foundational principles really will serve you well, not just hitting those multiple choice questions or writing that essay, but as you move forward in your legal career, tackling new questions about liberty and justice.
We absolutely want to extend a huge thank you once again to Angela. Her invaluable constitutional law notes really do make these podcasts possible. Her outlines are just fantastic resources.
They really are. And just a couple of quick but important reminders before we sign off. First, remember Angela is a law student, just like many of you listening.
Right. She's not an expert yet, and she hasn't passed the state bar, so keep that context in mind.
Which leads to the next point. Neither Angela nor this podcast is giving legal advice. Please do not construe any of this as legal advice. Think of us as a study aid, a tutor in your car, not your lawyer.
Definitely. And also, AI like us, we're powerful tools, but we aren't a substitute for putting in the hard work studying for the bar. We're an aid designed to supplement your efforts, not a shortcut.
Yes, please make sure this podcast is supplementing your learning, not replacing your casebooks, outlines, and practice questions.
And one more thing about AI. We aren't perfect. Sometimes we might make mistakes. Angela does her best to ensure her notes are accurate and tries to fix any errors.
But even great law students can make mistakes in their notes. And we, as AI, can sometimes miss things or misunderstand context. So always double-check critical points with primary sources or your main bar prep materials.
Good advice. Also, just to be clear, this podcast and the whole series are an academic, non-commercial venture by Angela. It's strictly for educational purposes.
And finally, the most important reminder, especially if you are listening in your car, please be safe on the road. Focus on driving. Don't cause a tort while listening to constitutional law.
Hey, good one. Safety first, always.
Okay, if you do want to reach out to Angela, maybe with feedback on the podcast or a question about the material.
The email for that is podcast@studyforthebarinyourcar.com.
And if you're an attorney or no one who needs help with research, writing motions, appeals, that sort of thing.
For Angela's freelance law clerk services, the email is hello@legalwriterandlawclerk.com.
All right. I think that covers the housekeeping. Which means...
It's time for the tradition, the cheesy Ninth Amendment joke.
Okay, you first. Why did the Ninth Amendment break up with the 10th?
Let me think. Because the 10th Amendment said, it's not you, it's just that I need my space and explicitly defined powers.
Oh, that's pretty good, actually. Fits the theme.
Glad you approve.
All right, on that note, this is Maude and Claude, your AI hosts, signing off.
We'll catch you on the next podcast. We'll be tackling the 10th Amendment, diving deep into the principles of federalism and that delicate balance of power between the states and the federal government. Thanks so much for listening.